Federal Court Monitor David Ferleger, Esquire, United States District Court for the District of Minnesota.
Hello, my name is David Ferleger. I work for Federal Judge Donovan Frank as his independent consultant and court monitor in the Jensen versus Department of Human Services case. This very important case was adopted by the court as an order in December 2011, and it's important to remember that both the state and the people who brought the suit at that time hailed the court's order and the settlement as being incredibly beneficial and a landmark case for both people in Minnesota and actually a model for the whole country. The settlement required changes in two ways. One is changes in the way the Department of Human Services cares for people under its care, and the settlement also required statewide changes and a statewide plan for all people with disabilities under what is being called the Olmstead Plan, named after a Supreme Court decision which guaranteed people the right to the most integrated care. So there are three concepts that are basic to the court's order. One is protection from harm. The second is person-centered planning. And the third is that people are entitled to services, as I mentioned, in the most integrated setting. So what do I do for the judge? What does a court monitor do? Many of you may not be familiar with that idea, but the court appointed me to be the court's eyes and ears, essentially to report to him on what's progress, what problems there are, what obstacles or challenges there are, and also to gather information from people like you who are entitled to talk to me privately, and from the state and from the plaintiffs, and to try to put that together in various reports I do for the judge so he knows on the ground what is actually happening. Another role I have is to verify information that the state provides me and to make recommendations to the state, to the parties, and to the judge. The last couple of years, there has been significant progress, and I want to applaud the department for the progress that's been made. There is an increasing focus on how the department and the state will fulfill the requirements of the court's orders. At the same time, to be complete, we need to recognize there has been some noncompliance which the court has recognized and which I think has been a spur to the adoption very recently in March 2014, the adoption of what we call the Comprehensive Plan of Action. This is essentially an implementation plan to help guide us toward a time when the court, hopefully soon, will no longer need to supervise the state's actions under its orders. Comprehensive Plan of Action is thus sort of a roadmap to compliance. So there are four things that I want to emphasize to you today. One is that the state, to its credit, has agreed to all that is in the settlement agreement and all that is in the Comprehensive Plan of Action. There is nothing you're hearing about that is something that has been imposed by a court from the outside without the state's full agreement to it. Second, it's very, very important that all employees of DHS and folks implementing the Olmstead Plan and the Comprehensive Plan of Action, that everyone know what is in those orders, that everyone know what is in those plans, because people will be held accountable in a positive way. And the purpose of this training is to help educate folks on what the requirements are under the court's orders. So we're engaged in implementing a court order, and there can't be any delay, there can't be any ignoring of a court's order. We have to be sure we all know how serious it is when a court orders something to happen, and how serious it is if that requirement does not occur. The third thing I think we need to think about and have in mind is that there's a very important agenda here, and The agenda is one that will be familiar to all of you, and the agenda is to ensure that people benefit from the court's orders and from the services that the state offers to people. None of this would mean anything if real people did not benefit on the ground, in their homes, wherever they are, from the court's orders and the state's agreement to implement those orders. So the last point I want to make is that I want you all to feel free to let me know any questions or concerns you have. The court's orders allow anyone to communicate with me in private and in confidence, so there's no need to be concerned about letting me know anything you know that you feel I should have in mind as I fulfill my job for Judge Frank. And then, I guess, most importantly, we need to be thankful, and I certainly am thankful, as is the judge, for all your dedication and service. It's really worth repeating that we thank you for everything you do, because without that, the folks who you serve would have less. And we need to be sure that everyone you serve receives the protections that you provide every day. Thank you very much.
Federal Court Monitor David Ferleger, Esquire. DAVID at FERLEGER.com. 215-887-0123.